Good, good, good. Oh, we're being recorded. I just got
Okay,
a
everybody.
notice across my tablet that we're being recorded. Okay, let me make that go away. Yeah, so it's the Equal Protection Clause, EPC. Now a trick question, and Jerry, if you don't want to answer this, you can certainly do what I call punting. You can punt it to a classmate. So, and let me tell you that across the board, if you don't want to answer a question, if you're not sure of the answer, you can punt to someone else. The problem is if you punt, then they can punt back to you later in the game. So, let me ask you this. Where is the Equal Protection Clause found in the U.S. Constitution?
Just 1 second. Giving you a moment to think. Professor Lawler, can you still talk?
I just put myself on mute because my dog's barking.
Can you say something again, Professor Lawler?
Yeah. Can you hear me now?
Yes.
Okay. Were we having audio difficulties?
A little bit.
Okay. So Jerry told us that the basis for her legal challenge of the Connecticut regulations is the Equal Protection Clause of the U.S. Constitution. Now, let me see who I'm going to ask. How about Omar? Can you tell me, please, where is the Equal Protection Clause in the Constitution? And I'll tell you that's a trick question. But where is the Equal Protection Clause in the Constitution?
It's on the 14th Amendment of the Constitution.
In the 14th Amendment. Yeah, that's exactly right. What about the Due Process Clause? Where is it? Anybody know? I wonder if I can, let me see if I can pull this up and share my screen. Okay, let me show you what it is that hopefully I can share my screen and you guys can see this.
Let me make sure you can share a screen. Just a second.
Oh yeah, you got to make me a host or a co-host, I think.
You should be able to do it now.
Okie doke. So can y'all see my screen?
No,
There it
Can
comes.
you see it now? Okay. So let's look first at the Fifth Amendment, which I am just pulling up at random. This is not the text of the Fifth Amendment. This is what I want. U.S. Constitution, Fifth Amendment. Let's see. Yeah. Okay, here's the Fifth Amendment. So look here with me. This is the verbatim. This is the text of the Fifth Amendment. And you see it says down here, no person shall be held to answer for capital or otherwise infamous crime and I'm skipping, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of, this is the part I want you to concentrate on, life, liberty, or property without due process of law. Okay, so this is the Fifth Amendment, and this is the due process clause. Now let me back out and let's look at the 14th Amendment, which I believe Jerry told us is where the Equal Protection Clause is. So the Equal Protection Clause here, this is the 14th Amendment. This is not the 14th Amendment. We got way more than we want here. Oh, here we go. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That sounds vaguely familiar, right? Didn't we just read this almost verbatim in the Fifth Amendment? So why is it at two places in the US Constitution? Why do we have two due process clauses? Does anybody know?
Yeah, the different one relates to states.
Okay, well, hold on. Let me quit sharing my screen because I want to know who said that, because that was really great. Who said that?
That's me, Natalia. I don't know who
You
you're
back?
here.
Oh, okay. So you're completely off the screen. No wonder I didn't know who said it. Yeah, that's right. So the first 10 amendments apply to what kind of action? State action or federal government action?
Government.
That's right. And so they wrote the 14th Amendment to extend that due process clause to state action as well as federal action. Well, what are we talking about in this case? Henry Griffiths, was it a state action or federal action that she was complaining about? State, right. So that's why Jerry was exactly right that we look to the 14th Amendment for guidance. And there's two things there, the due process clause and the equal protection clause, that you really are going to have to understand. They're foundational to all of our individual rights in the United States. And the 14th Amendment expands that due process right, that due process protection, I should say, to state action as well as federal action. And what she was complaining about here was state action. The state of Connecticut was preventing her, or the Board of Bar Examiners, the Office of Bar Admissions in Connecticut, was preventing her from sitting for the bar exam and becoming a licensed attorney in Connecticut. All righty. So you read an excerpt, you didn't read the whole case, but you read an excerpt, pieces of it that Dr. Bunting and I have pulled from the case that we really wanted you to understand and that you need to understand for the final project that's upcoming. So tell me this, who shall I call on? How about Ruth? Ruth, can you tell me, going through the questions that you already have answered, so these should be pretty easy for you. At what court was this case being heard in?
In the Supreme Court of the United States.
Supreme Court, yeah. So was this a trial court or is this an appellate court?
It's an appellate court, only the first.
Yeah, in fact, it's the highest appellate court. And one thing, I'm not sure if you guys have done this in Intro to US Law. I assume that you have. I bet that you have. But the highest appellate court on a federal matter is the US Supreme Court. But the final voice on an issue of state law is what court?
The Supreme Court, but they can go for a federal question to the US.
Good. I'm glad to hear that Ryan Redberry is training you well, because that is a perfect answer. Good. Okay, so Ruth, back to you. What was the vote in this case?
7-2 to the
7-2. Yeah. So there's 9 justices, and this was 7-2. Let me call on somebody else. How about Zalima? Can you tell me who wrote the majority opinion? Who wrote the opinion for the 7 that?
Joseph Powell.
Good, okay. And who did he fine for? Who, in Powell's opinion, that was agreed to by 6 other justices, who did they fine for? Did Frey win or did Frey not win? She won. So did she ultimately get to sit for the bar exam? Did they determine that she should be able to sit for the bar exam? So they determined that it wasn't really about her being able to sit for the bar exam. It was the constitutionality of this regulation, this bar examination regulation that prevented her from sitting for the bar exam and becoming a licensed attorney. So it had huge implications. It wasn't just about this one person in Connecticut who wanted to become a lawyer and who had gone to law school. It was bigger than that. I mean, what other issues are there? And we've already talked about the fact that this parallels some of your lives and that some of you came to the United States, ended up in the United States because you married somebody in the United States. But what else is implicated here?
The security, the national security, they say, the state of Connecticut say that it's a issue related with the national security because your interests are compromised with your original nation.
Good. So you're exactly right. So there's these different, there's a national interest in security. What in the dissent, what was the dissent's argument? Why did the dissent think that the regulation in Connecticut should be found valid?
The dissenting say that two things that for me is not related or no reason for deny the petition, but he say that she don't know or the non-citizens don't know the history, the cultural facts of the country to make decisions.
Good. So I'm going to open this next discussion to anybody. I'm not going to call on somebody, but just open it to anybody. Let's see if we can, even if you don't agree with the dissent, even if you think that the majority opinion was right, and we probably can all agree that the majority opinion was right here, and it was 7-2. But what are the two sides of this argument? So on one side, there's a woman who wants to become a lawyer, and she has pride in her her citizenship in her birth country. But what else is at stake here for her? What is at stake? Not just citizenship, but what else? What is a really big issue at stake for her?
Right to work and provide.
Who said that? Because I'm not. Okay, good. Thank you. Perfect. That's perfect. Exactly. The right to work. I mean, what more fundamental issue can a person have than the right to earn a living, to be able to, pay rent like I'm paying, or to be able to buy food for your family? I mean, that the right to work and to work at a profession that you've trained for is pretty fundamental. What else is at issue here? So somebody said national security and the right to work. What else? Can you put anything else on the plate?
I think it's also trying to define when the states can create categories to separate a person. And it was like telling that it have to be like really related to the goal, the main goal of the state is looking.
Good. Y'all are great. I've heard that you're a wonderful class and you're living up to what I've heard. This is great. So now the other side. So now let's take a step over to the dark side and try to think like the dissent. Tell me what are the priorities of the other side? Anybody?
14th Amendment, the protection clause does not apply to any kind of classification, but it only applies to race, like a minority, like a disparate and insular minorities. and that actually the Constitution makes a differentiation between citizens and alien residents. So they are going against the Constitution itself when they are not allowing the state to consider this difference in their own requirements for the bar.
Well done, really well done. So great. So question 2, we've already answered in our discussion. Who is the petitioner? And somebody tell me who she was and what state law is she challenging. And the law was actually a regulation about bar admission, but it was indeed a state regulation. All righty. So, and what was her status? Let's see, who should I ask? How about, I've called on most of you, haven't I? How about Moritz? Moritz, can you tell me what was her status in the United States? So we know she was a citizen still of the Netherlands, but how long had she been in the United States, and what was her status, her citizenship status, or her lack thereof?
For immigration law purposes. And I believe she's been in the States.
It's like 67 to 72.
Yeah, she was there 8 years at the time of the case. I think the time the case was appealed to the Supreme Court, she had been in Connecticut for 8 years.
Yeah.
8 years.
1965, she applied in 1970 for permission. Yeah, but case was decided in 17, that's why.
Okay, so now a big question. The next question is a big question, question number 3. And I hope that you all got this right, and I hope that you understand it, because this is going to be a key thing for you to understand as you enter the final project. In deciding the case, what level of scrutiny did the Supreme Court of the United States apply?
Close judicial scrutiny, since there is government action involving a suspect classification such as race, religion, national origin, or alien.
Okay, and I'm sorry, what level of scrutiny?
Those. Close.
Okay, so CLOSE. Okay, so there are 3 levels of scrutiny under the Equal Protection Clause of the United States Constitution. And the highest one is what we call close or strict scrutiny. It's more commonly referred to as strict scrutiny, but this court, I think, does indeed call it close scrutiny. You're exactly right. And then there is a middle level, which they call intermediate. And then the lowest level, anybody know what the lowest level of scrutiny is? There's no reason why you would know it now, but if you do know it, unless you've already done Chapter 6 in Introduction to U.S. Law, and I don't think you have.
It's rational.
Good. Have you done Chapter 6 Constitutional Law and Introduction?
Constitutional law at Professor Kinkoff.
I'm sorry?
I'm hearing constitutional law at Professor Kinkoff.
Oh, right. You're taking Kinkoff, right. But not everybody in the room is taking constitutional law right now, right? I'm sorry?
I got it from our tutor, the rational.
Okay, good. Who's your tutor?
Duncan.
Good. Duncan's great. Tell Duncan that I said hello. So you're exactly right. There's 3 levels of scrutiny. The highest one is strict scrutiny, intermediate level of scrutiny, and then the lowest level is rational basis. So depending on which level of scrutiny the court is applying, they use a different test to determine whether or not a state law or a federal law or a state action or a federal action is constitutional. And here they used strict scrutiny. And note that when strict scrutiny is used, do they usually find that a law is constitutional, or do they usually find that a law is unconstitutional? And that question is for Winston. When strict scrutiny is applied, I'm gonna try to ask it more clearly. I don't think I was very clear. When strict scrutiny is applied by a court, Is the statute that is challenged usually held to be invalid or valid?
Invalid.
Good, that's exactly right. So it's a really high level of scrutiny. They require a lot under this test. And so usually when that test is applied, the statute or the government action is going to be stricken. It's going to be found to be invalid. And indeed, that's what happened here is they found that this Connecticut regulation was invalid. So opening it to the floor, I'm not going to call on somebody. I just want to volunteer. What did that require? What did the court say when close scrutiny is applied, when strict scrutiny is applied? What is that test? What are they looking for?
Justification.
So I'm not hearing, I hear voices from the middle row in the back of the room, and that's who I really want to hear. But I can't understand. So you got to talk loud, and it's fine to talk loud, even if you're unsure of your answer, because this is a safe sanctuary and we're learning this together. So this is a safe sanctuary. But what is it that the court, what is that test that they apply?
Every burden of justification, the state would have to prove that its interest is compelling, constitutionally permissible, substantial, and the classification, the suspect classification is necessary.
Good. So I heard some really important words there, that it's a heavier burden on the state. And the state has to prove that it has a substantial interest. I heard that. I heard substantial. And there's one more little twist to it. Anybody know what the other, and if you already have learned this with Neil Kinkoff, I'm so impressed, because this is really a Con Law 2 issue, not a Constitutional Law 1 issue. So I'm very impressed that he has already trained you in this. But does anybody know what the other little wrinkle is to this?
The classification is necessary to accomplish for the accomplishment of the person.
That's right. It's necessary, not just it's a good way of doing it, but it's necessary. And you will also see in some of the cases that that you're going to study and read, is that there's not a less restrictive way to do it. The state has to prove there's not a less restrictive way to accomplish its goal. And so this Connecticut regulation failed under that high level of scrutiny that was applied. This Connecticut regulation failed. So the court didn't say at the end of their opinion, we find that Frey should be able to sit for the Connecticut bar exam. Their finding was that this regulation is unconstitutional. So question number 4 here is, what adjectives does the court use with substantial? What are some of the other things that they said? So it has to be a substantial interest. What else can we use there?
Compelling, important, overriding.
Perfect. So substantial, overriding, important, compelling. All of those are kind of little keywords that when you hear, you know the court is about to apply or is applying the strict scrutiny standard. Good. And note that the court will apply it well, somebody already said this to me, and I'm going to ask you to say it again. It doesn't have to be the same person. Anybody can say it. When does the court apply strict scrutiny?
When there's a government action.
Yeah, but what kinds of challenges?
When the
Right,
the law is constitutional or not constitutional, whether it's a valid law or not valid law.
Good.
Also, when it's
Let me
about-
ask it a different way, because I'm not getting what I want. What you're saying is accurate, but it's not what I want. So the classification that is challenged, if the classification involves certain groups of people, then strict scrutiny is applied. What kinds?
Race, religion, national origin, or alienation.
Classification.
That's right. So what did I hear? I heard national origin. I heard racial classification.
Discrimination.
What else?
Religion.
It's okay. So keep all of that in mind. Bank that away in your memory bank, because you're going to need this knowledge as you go through the final project. Okay. So did the Supreme Court determine that Connecticut had a substantial interest in deciding who has the right to practice law in their state?
Yes,
Yes.
yes.
Yeah. Yeah, and I mean, that's kind of inarguable. And we as lawyers and you as lawyers who now want to become licensed in Georgia can understand that. Of course, the state does have a very substantial, a very compelling, a very overriding, a very important interest in determining who can become a lawyer in the state of Georgia. And so that wasn't where this regulation failed. It wasn't that the state didn't have the interest that it needed to have to justify the regulation. Where did it fail? What did the court say was the weak part? Why did the Connecticut statute not stand?
Because it went beyond the character and general fitness of the requisites in order to sit for the bar and went to the discrimination between citizenship and residency.
Right, because Connecticut could not justify the exclusion of all resident aliens. And that's what she was. That was her status, she was a resident alien. Am I correct?
Yeah.
Yes.
Right.
Question? please?
Yeah.
The burden, the scrutiny level, is it because the classification is based on alienation and making a group of people not allowed to do something that a general public or citizen are allowed to do?
Okay, great question. So sometimes, yeah. And so let me think of some more recent Supreme Court decisions that will bring this to light. Do you guys know the Obergefell case? Have you studied that yet with Ryan Rayberry on Monday nights? So I don't think y'all gotten to chapter 6 in that class. So you will talk about it when you get to chapter 6. Obergefell was the same-sex marriage case from, I think, 2015. I think it was 2015. And it's included in your book. And so you will indeed be familiar with it. So Obergefell was determined both under equal protection and also under due process grounds. And what happened in that case, I'm giving you a preview of something that you'll study later in the semester in another class, but what happened in that case was different states in the United States had different laws about same-sex marriage. So Georgia, for example, we had it in our Constitution, not the US Constitution, but in the Georgia Constitution, it had a definition of marriage as being a union of one woman and one man. But then other states recognize same-sex marriage, and marriage between two people of the same gender was completely legal. Well, what happened was we had this patchwork of different laws around the nation, and it was a big mess. And so a group of plaintiffs challenged the different laws in their different states under the Equal Protection Clause and also the Due Process Clause. And so the Supreme Court came to the decision that they made, which was that, first of all, marriage is a fundamental right, as is education, as is the right to earn a living and to work, to practice law if law is your profession. Those are fundamental rights. And so the United States Supreme Court determined that same-sex marriage was constitutional, and the states had to follow that leadership, because remember, that was an issue of federal law. And so the US Supreme Court is the final voice on issues of federal law. But that was a challenge from people who had been treated differently under state laws, and they challenged it under our federal Constitution. Now, let me ask you, is that strict scrutiny? What I just explained to you, that the whole scenario that I just told you about same-sex marriage, should that get strict scrutiny, intermediate scrutiny, or rational basis scrutiny?
No, it should
No,
be-
You get straight.
I'm hearing a bunch of different answers.
That is heightened scrutiny.
Heightened scrutiny? So not rational basis. I mean, the name rational basis kind of tells you what that scrutiny is. The government just has to show that it has a rational basis for its statute, a rational basis for categorizing people differently, for classifying people differently and treating people differently under the law. You just have to have a rational basis for it. Intermediate is heightened scrutiny, and that's exactly right. But strict scrutiny gets the very highest level of, or close scrutiny gets the very highest level of scrutiny by a court. So let me ask you, I'm giving you again another preview of con law. Gender issues. So if I am treated differently because I am female, and one of my coworkers, I find out, makes more money and he's a man, and the only different, we have the same qualifications, we've been at the university the same amount of time, what level of scrutiny would that get? I hear all the women saying strict scrutiny, especially because I made it an issue of a woman being paid less than a man, but it could go the other way too. It could be that one of my male coworkers finds out that he's getting paid less than me. You know, it can go, of course, either way. Are you surprised to find out that it's intermediate?
Yes.
No.
So, okay. So what about, here's another one. In the United States, when you are, if you, I think they just changed the law in the last decade, perhaps. You used to be, you would get Social Security when you were 65, but then they changed it. I think people born 1960 or later now have to go all the way to 67 to get Social Security benefits. And I may be wrong about that. So I'm just using this as an example. Don't quote me on that. So what if I'm not that old and I want Social Security? What level of scrutiny would my challenge receive? Would it receive strict scrutiny, intermediate, or that lowest level of rational basis? Yeah, that's exactly right. I gave you an example that was kind of an easy example. I should have given you a harder example. But yeah, age discrimination is also covered by the Age Discrimination and Employment Act, ADEA. But if challenged under the Equal Protection Clause, then it would get that lowest level of scrutiny, the rational basis. But when it is an issue of racial classification, or if it is an issue of national origin classification, what level of scrutiny does it get? Okay, and I think I've gotten so far removed from the question that was asked that I'm not sure I gave you a good, clear answer. But what these are challenges that come from people who are affected. So Frey LaPoule, she was totally affected by this. She had standing to challenge this regulation because she was unable to sit for the bar exam, even though she had gone to law school, even though she graduated from law school, even though there were no character and fitness issues, she was not able to sit for the bar exam in Connecticut because of this practice rule. When 8.1, didn't somebody tell me it was 8.1? I think Ruth did. So she was affected by this, and so she was able to challenge that regulation, went all the way to the U.S. Supreme Court with her challenge, won at the Supreme Court level by challenging it under the Equal Protection Clause. And it got that highest level of scrutiny for what reason?
Racial, it doesn't have to do with race.
It didn't have to do with race. It had to do with national
It was
origin.
a classification.
Yeah. That's right. That's right.
Question.
Good.
So we say you get strict scrutiny because it's nationalization or race, because it's a classification based on those two criteria. So how is it decided what classification should be strict? Like classification between gender, why does that get a lower level of scrutiny?
Well, let me ask you that. I'm going to throw that right back at you because you have enough knowledge now of the American legal system that you should be able to answer that. Who determines that? So these are issues of federal law. And we know in the United States that we have a common law system, and so we follow precedent. So who is it that's making this distinction? Who tells us what level of scrutiny we apply in each of these challenges?
Based on court decisions?
The court's decisions, right? We look at precedent. So what the Supreme Court tells us is what all the lower courts also have to do. So the U.S. Supreme Court has determined these classifications get strict scrutiny, lower classification, or not lower classifications, but more different classifications, distinct classifications get intermediate or get rational basis. Who on the court do you figure thinks that issues of gender discrimination should be elevated to strict scrutiny? Because there are people on the court that think that.
The females in the court.
That's right. That's right. It's the women. It's the women who think that issues of gender discrimination ought to be elevated to strict scrutiny, and then perhaps they will.
There should be a bigger variety of
Women.
gender and backgrounds and just experiences in the court, because it's currently lots of white males, right?
Well, no, not so much anymore. I mean, there are, how many women are on the U.S. Supreme Court now?
Sorry?
How many women are on the U.S. Supreme Court now?
Four.
No.
Three.
Anyone?
Anyone?
The new one?
Anyone in Blackberry or whatever.
I'm gonna find a picture of them. We're gonna look at them together. This is like the fun stuff.
Yeah. There's,
Yeah, three. I think it's, no, it's four.
It's four. There's one in part of
This
it.
was not meant to be, this wasn't supposed to be a trick question.
It's four.
Okay, wait a minute. I'm gonna share my screen. Here we go. Can y'all see?
1, 2, 3, 4. It's
Yeah,
four.
four.
Yeah.
Yeah.
Yeah. Okay, so let's see. Who's the newest member of the U.S. Supreme Court?
Becca Daniel Brown.
Yeah, right.
oh, it's not.
Yeah, can y'all see my cursor, my dancing
Yeah.
cursor?
Yes.
Okay. Okay, so yeah, she's the newest member. Who is the Chief Justice of the U.S. Supreme Court?
Medium.
The middle.
Yeah, in the very middle. Yeah. And what is his name?
Justin John Roberts.
Yeah, and I should have asked you, what's her name, the newest member?
Brown.
Good, good. So, who is the only Supreme Court justice from Georgia?
Clarence
Clarence Thomas. Yeah, he's from a tiny little town outside of Savannah called Pinpoint, Georgia. Yeah. And let's see. Who's this?
Oliver.
Yeah. Good, good. Who's this?
Sotomayor.
And who's the other woman?
Elena.
Good, y'all are good. So these two guys, well, actually, these two have not been on the court all that long. What's this guy's name? Gorsuch. Yeah, he's from Colorado, I think. And who's this? When he was nominated, well, how do you get on the Supreme Court? Who nominates you?
The president.
And then who votes on that nomination?
The Senate.
The Senate, not both houses, not the House of Representatives and the Senate, the Senate. Where do we find the rules about that?
Constitution.
Yeah, good. And you're gonna learn more about the Constitution as your training at the College of Law proceeds, but there are 3 articles, Article 1, Article 2, Article 3 at the beginning of the Constitution. And those 3 articles give us the rules for the 3 branches of the government. So Article 1, anybody know what that is about? What branch of the government?
Legislature, yeah.
The legislature, yeah, so Article 1, Section 8 has a long list of congressional powers that we call the enumerated powers, and you'll hear more about that as you go through your studies. Article 2 is about what branch of the United States? The executive, right. And so it tells us things like how old you have to be to run for president of the United States and how many terms you can have. And then Article 3 is about that last branch. What's the last branch? The judicial. And so it defines, Article 3 actually defines the powers of the judicial branch, and it creates only one specific court. What is the one specific court that Article 3 creates?
Supreme Court.
The Supreme Court. And so the Article 3 tells us that the Supreme Court of the United States has appellate power. They hear appellate cases, just like they heard in this case that we're talking about. But also they have original jurisdiction, which means they can hear the very first conflict. They can hear it before it comes to on appeal, only in certain cases. What things can the Supreme Court hear in with original jurisdiction? Anybody know?
Constitution, anything to do with the dispute
Madam
between
Ambassador.
states.
I'm sorry, I'm not.
States.
So if there's a dispute between two states, that's right, then the US Supreme Court could hear that. Disputes with diplomats or ambassadors, the Supreme Court can hear that. But no, not all constitutional issues. Constitutional issues have to go up through different layers of appeal, just like other issues have to come up through layers of appeal. Did we talk about every single one of these? I don't think we talked about this guy. Who's this? Yeah, he's been on the court for a while. These three here have been on the court the longest, I believe. And he's been on the court for a while. All right, I'm going to quit sharing my screen and let's finish up these questions. So, oh, I know what I wanted to talk about. Question number 6. What is this big deal that the Supreme Court is making about being an officer of the court? What are they talking about there?
They're trying to differentiate between an officer of the court that is like a bailiff or a court clerk that is actually under a certain office employed by the courts to carry out duties on behalf of the court. They're trying to separate that from a lawyer or an attorney who is actually in private practice and has his own clients and kind of like pays his taxes and does his own thing, different from, you know, being under the you know, like an organization basically.
Right. So
Yeah,
so they're making a distinction between wanting to become a lawyer in the state of Connecticut and being an officer of the court. I think you said like a bailiff, right? Yeah, like someone who works in the courtroom, who was employed by the court. The Supreme Court makes a distinction. And why was that important?
Because they're trying to put them in the same category. They're trying to say, well, it's said here in 23 that it has been stated many times that lawyers are officers of the court. But then this is just, yeah, they're using it in like a loose term of officer of the court, as opposed to like marshals or bailiffs and court clerks, who unlike these officials and lawyers who are engaged in private profession. So they're trying to say that even though the lawyer is being addressed as an officer of the court, he's not in the real sense an officer of the court because he has a different kind of role that he plays in comparison with, you know, these ones that are true officers of the court because they're employed by the court.
Perfect. That's exactly right. But why is the court even concerned with that? Like what difference would it make if we said, yes, she's an officer of the court or no, she's not an officer of the court? Why are they concerned with that distinction?
It's required for those federal positions.
And the commissioner brought it up as an argument.
I'm sorry, Ruth, what did you say? Different what for those positions?
Because citizenship is an element for that kind of positions, if I'm not wrong. like federal positions require, they do differentiate between residents and citizens in order to be able to be an officer for the court. So they're trying to bring the same distinction to an
Good.
officer for an attorney.
Good. So you're kind of dancing around what I'm trying to get to with this, but how would that affect the court's analysis if she was found to be an officer of the court, which they said she was not?
Racial issue.
I'm sorry?
Then it would be based on race.
Oh, good, good, good. Yeah. So it might affect the scrutiny, right? They might not use strict scrutiny. So if they weren't using strict scrutiny, then that regulation might be upheld, right? So that's why they made a big stink out of whether or not she was an officer of the court. And you will hear, you know, as you begin the practice of law, you will hear people refer to lawyers as officers of the court. And so I want you to kind of understand that and understand that the Supreme Court has made this distinction in this case, but don't get confused if you hear somebody refer to you as an officer of the court when you're practicing law in the United States. Just wear that badge proudly. Okay, so the court, the final holding of the court here, did they hold that the alien lawyer may not represent his or her country in a case against the U.S. government? This was question 7.
They say that representing foreign country, when an attorney represents his own country against United States, it may constitute a conflict of interest.
Good. So it actually is in a footnote. It was in footnote 4 where the court discusses this, and the court says that they would hope that any honorable attorney would decline to represent another country against the United States. If you're licensed to practice law in the United States, we surely hope, says the court, that you would decline to represent a foreign country against the United States. But does the Supreme Court come to a final holding on this? Do they make a decision?
No.
Good. No, they don't. They skirt the issue. They go, not for us. We had to deal with this whole thing with Frey in Connecticut. We don't have to deal with that. We will kick that can down the road and let another court determine that on another day. Is a resident alien attorney permitted to bring a case before the United States Supreme Court under the Equal Protection Clause? And this is only for somebody in the back row. This was question 8 in your questions, and only somebody in the very back row can answer. So
Is it discrimination?
Yes.
and the answer is yes. Obviously, the answer is yes, right? Because they let Frey do this, right? Frey was victorious. Go Frey, right? Yay, Frey. I think this is a fascinating case. I think it's a wonderful case for you to begin yours. If one of you at least, how many of you have Neil Kinkoff for common law? Is it just Moritz?
Yeah, it's just me, I think.
Okay, anybody else taking common law?
No.
He's the only one. Okay, so this is kind of a good case to get your feet wet in the discussion of constitutional law. I love constitutional law. I find it tremendously fascinating. I love this case, and I love that we pulled this case for all of you to begin your studies for the final project, because it's so interesting. And the first person that commented on the case said, Frey's life is a lot like her story is a lot like my story. So I hope you enjoyed reading it as much as I enjoyed talking about it with you. And now I'm gonna, well, any questions, anything else you guys want to talk about before I hand it over to John? I'm not leaving. I'm going to stick around. I haven't seen John Bunting teach in 9 months. And so I'm going to sit and listen to John Bunting teach and enjoy the moment. But anything else that you guys want to talk about before we head off of Frey?
Yeah,
Yes.
Question regarding question 6. When you say officers of the court, are they trying to make a distinction between agent of the country, like in international law, when you need to determine if a person's action is linked to a specific country, And here they're trying to make the same distinction with the judge or the judge behavior or clerk behavior will be linked to their duty to the country, but an attorney is not directly linked to the US as a government.
Yeah, yes, and the other distinction is whether or not the person challenging a statute or a regulation or a government classification is actually employed by the state. So in this case, it wasn't about whether or not she was looking for employment with the state. She wasn't. She was looking to become licensed by the state in order to exercise her fundamental right to earn a living. But you're exactly right. Beautiful. Any other comments or questions?
Is there any sanction or can we review a decision simply because it wasn't based on any kind of scrutiny, strict or intermediate or rational? Is there any sanction to that? Like we're expecting the judge or the court to use strict scrutiny and they didn't. So yeah, is there any sanction to that?
Are there any sanctions? You mean, does the state get punished for having this horrible classification?
If they don't use the classification we expected, let's say in this case, if they didn't use strict scrutiny, is there any way to review their decision? Like saying, okay, you should use strict scrutiny, but you didn't use it.
Well, the Supreme Court is the final word on issues of federal law. And so if the Supreme Court says we're going to use strict scrutiny in these classifications, but not in these other classifications, that's the final word on that, on whether or not the strict scrutiny it can be applied. But who has the final word on our legislation? Yeah, the legislative branch. So so there's this kind of this is an interesting conversation actually, because we have these three branches of government, and we have checks and balances between the three branches of government. So if the Supreme Court determines that a law is unconstitutional because it offends the Equal Protection Clause, or it offends the Due Process Clause, or it offends the Commerce Clause, or whatever, if the Supreme Court determines that a law is unconstitutional, then it can bounce back to the legislature, and the legislature can rewrite the law and try to rewrite the law to accomplish its goal in a constitutional manner. And so there's this, not tension, but there are checks and balances between the branches, and that's one of them. The Supreme Court has the power of, what do we call that power, where the Supreme Court determines whether or not legislation is constitutional?
Judicial review.
Good. The power of judicial review. Who said that? Okay, thank you. Thanks. I just wanted to know who I was talking to. That's right. So that's exactly right. So the Supreme Court determines whether or not it's constitutional. It can bounce back to the legislature. The legislature can try to rewrite the law in such a way as not to offend the Constitution. Or sometimes the Supreme Court will determine this is an issue of state law, that this is not something that the federal government should be messing with at all. This is something that states should be determining. What very controversial area of the law did that happen in the summer of 2022? Anybody know what I'm talking about?
Abortion.
Yes, exactly. So that's, the Roe versus Wade had been the law since the 1970s. That Supreme Court case was upheld since the 1970s. And then in the summer of 2022, the Supreme Court bounced it to state courts and said this is more an issue, or not to state courts, to state legislatures, and said this is an issue for states to determine. So you see, there is kind of a tension. Actually, I said that wasn't the right word, but there is some tension there as well. And there are so many checks and balances between the branches of our government, and we could discuss them all night long. But the ones that you need to be most aware of are judicial review, obviously, the fact that the judicial branch of our government has not just the duty, but the authority, or not just the authority, but the duty to determine whether or not our laws are constitutional. And then the legislature writes laws. So if they want, they can rewrite it. And when you study the Commerce Clause, which Moritz has obviously already studied, the Commerce Clause, and all of you will when you take constitutional law next semester. No, next summer. Yeah. When you take constitutional law, you'll take a deep dive into the Commerce Clause and you'll see how that plays out. Congress, one of the enumerated powers of Congress is the Commerce Clause. And remember I said in Article 1, Section 8, there's a whole long list of congressional powers, and one of them is the Commerce Clause. And Congress uses that Commerce Clause authority to write ever so many pieces of legislation. But if they exceed their power, if they are writing a law under the Commerce Clause authority and the government, and this law that's passed by our federal government is then challenged by a citizen like Frey, who's affected by a law, who has standing to challenge the law, and the Supreme Court determines that it was that the Congress has overridden its power, then it'll be determined unconstitutional. I know that's a whole lot. Like I've given y'all constitutional law in a nutshell there, and that's a whole lot. But it's interesting. And this is my only chance to talk to you about it. Although I will be back next week, so we can talk more about it next week.
What, Professor Lawler, it's so great to hear you.
It's so
talking
great
about
to
all
be
of
here
this.
with you. It makes me miss you though. I'm going to put myself on mute, but yeah, it's really great to be here. And I do miss teaching with you, John, and I do miss seeing all of y'all. So I'm going to put myself on mute.
Well, we are talking about doing a road trip up to that mountain view of yours.
You're invited anytime. The leaves are just starting to change, and you know that. You're invited anytime. But I'm going to mute and listen to positives now.
Okay. Well, I think what I'm going to do is give everyone a break for a couple minutes. So you can also take a break if you want. You can blank out your screen. We'll be back in, let's say, 10 minutes. Okay, take a break. Thank you, guys.
So, I think, I guess it's gonna be this big, because it's more like you can work with,
More helpful. You can choose one or two. No, I mean, for. I need your.
Leila, can you hear me? Professor Lawler?
Yes, I can hear you.
Oh, good. You know, during the break, a couple people were asking a little bit about the Sugarman dissent.
Uh-huh.
Would you be up for, let me do the positives and then maybe towards the end of class, if you want to just talk to them a little bit about that dissent? You feel up?
Yeah, or maybe hold it till next week,
Okay. Yeah, I think that sounds good.
because it's not a lengthy conversation, so
No,
probably
no, it's
something that we can do.
Okay, so we'll do that. I'm gonna have them read Ambach for next week as well.
Okay, so we'll do the Sugarman dissent and I'm back.
And you're coming back next week? Is that what I'm hearing?
I think I am if I'm invited.
Yes. I'm very happy. See, we can do it with
Okay,
technology. We got it.
It's so fun to teach with you.
Oh, man, I miss this. That's why I'm very happy.
Back at you. Thank
All
you.
right, I'm gonna get started with this crew.
You don't, you have to say, no. I think that what piece is one of the I don't agree with that. Yes. Today. Yeah, so you're gonna take like. No, I agree with you. Please say, like, you say. Now we know. I guess that's.
It's not like.
But I think that also means that they don't even go out. All what you expect, and then they're so free to. Because it's already when you say you're gonna go like with these 11 motion, but you said I need to, I mean, I'm sure it's not, yeah, but it's not bad. I can hear you.
Okay, everybody, I'm gonna pull you back in. Just when I thought I lost you. I also spoke with Professor Lawler. She's gonna be here with us next week. And we're gonna go over a little bit of the Sugarman dissent, but also with another case that you're gonna be reading that is in a way connected to that, kind of in the same vein as that. And just so you know, Professor Lawler's still here, so she may just chime in on occasion here as we're here. So
I'm here, I'm chiming in.
So this is one of the things that I want to do is just bring up a few grammatical elements that I think are very useful for you to have in your toolbox. And part of what the purpose of this is so that you can be very efficient and effective when you have to put a lot of information into a small number of words or a small number of pages. Professor Lawler mentioned there's going to be a final project here. There are strict page limits for this assignment. And you may find there are a lot of things that you would like to write, but there's not enough space. So you have to become very efficient and effective with your writing. So does anyone know what a positive is? Is anyone positive that they know what an appositive is? You're positive that you don't. All right. Okay, well, that's just a grammatical term, but I think once you see it, you will recognize it. Now, let me see if I can make this work. Okay, so here are four. Get rid of that. Here are four lovely sentences, and I'm going to ask Julio to read that first sentence.
Okay, Oliver Wendell Holmes, a former U.S. Supreme Court Justice, wrote the majority opinion in the controversial Buck versus Bell case.
Thank you. And I will mention, and I know she's biting her tongue, Professor Lawler is looking at this and saying, John, you shouldn't use just U.S. like that. It should be U period S period. Isn't that right, Professor Lawler?
I'm biting my tongue.
The where?
U.S. in front of the U.S.
No, because we have a form. A form.
Yeah.
So that's okay.
Yeah.
Otherwise, it would be that. You're right.
Yeah.
And no, what about that second sentence?
A long-serving Supreme Court Justice Ruth Bader Ginsburg wrote many opinions on landmark cases.
Yes, I miss her terribly. Samesh, could you read the third one?
Evelyn Gray, Nicole Perkins is a citizen of the Netherlands who came to the United States in 1965, originally a visitor.
Omar, what about that last
Hammer B. Norwich, a case involving working in the U.S. is a good resource with which to study alienation, the state of being a non-citizen of the United States.
one? So notice there's that term alienage, and that's the term that we're going to be seeing a lot of. And I will also add, before she gets to it, I really should have written out the word United States here. When it's a noun, you shouldn't even use the US. You should just say in the United States when it's the noun. When it's an adjective, you can say U period S period. I put these in there on purpose just to highlight. It's not a mistake, even though it may look that way. So we have four sentences here. Have any of you heard of Ruth Bader Ginsburg?
Yeah.
A long-serving Supreme Court justice. And maybe I should have actually had justice capitalized there too. Some say she was too long-serving. Me. Because she was very, very old and she did not retire when there was she's more of a Democratic, has a Democratic, more liberal philosophy. And she did not retire when the president was Barack Obama, who could have then appointed a new Supreme Court justice in her place. Instead, she waited with the optimistic view that we all have, that we will live longer. And she unfortunately did not. And then Donald Trump was able to replace her on the court, which did a lot. So what do you notice? Is there any grammatical element that you notice that's the same in all of these? Hey, I love a good comma.
And like, it's called qualifications, like this.
Nice.
Qualifiers.
Qualifiers.
Yeah.
That's a great way to describe it. So there's a noun that's being qualified by another noun phrase. So it's a way to describe someone with another noun phrase. And that is an appositive. So, what did I just do? Am I going backwards? Yeah. Let me show you if I can get this to work. technology and me tonight has been a struggle. I turned the machine off twice, not once, but twice. I'm a little nervous. Let's see if it'll work. There. Those underlying things are the appositives. So, and as you guys were pointing out, there's a lot of commas involved. And there's no verb really.
The description.
Yeah, it can be a description. It can be a definition. It can be a key important point about another noun. So, for example, we know that Oliver Wendell Holmes is a former Supreme Court justice. Ruth Bader Ginsburg was a long-serving Supreme Court justice. The appellant is Fred LeFoule Griffiths, and so on. And notice in this last one, we actually have two. We give a description of the case, and then we give a little definition of what alienage is. So, it keeps going. Oh, there it goes. So an appositive is a noun phrase that defines, restates, or gives important additional information about the nouns a noun that is immediately next to it. And as you guys noted, it's usually set off with commas. You can also use dashes or parentheses. Those are still considered appositives. They can be placed before or after the noun that it refers to. It's more common that it comes afterwards, but it can be either. And why do we want to use these? Because rather than giving short, choppy sentences that say, Ruth Bader Ginsburg was a long-serving Supreme Court justice, period. She stayed too long. Actually, I don't know what they said. That's what I'm just putting in there. You can add additional information without interrupting the flow of main ideas. Because for you as a writer, the main idea that you want to get across should be the main subject verb of the sentence. So you can add other kind of what we call asides. You can add things that add a little extra information, but it doesn't warrant creating a whole new sentence. Because every sentence that you create is creating extra work for your reader. And every sentence that you create has the reader will believe that you're saying this is just as important as the other sentences. This is a way to also give priority to your ideas. So that you say, here's my main thought, but I'm going to give you a little bit of extra ideas in there, like a definition. I don't need to give a whole separate sentence to give you a definition. So that's what the appositives are. So in the first one, you can see there's the main noun, and the appositive can just be removed completely if you wanted to. You can just say Oliver Wendell Holmes wrote the majority opinion. Fine. This is just dropped right in. No need for new grammar. We just drop in a noun phrase with commas to add the extra information. And it's important information. It may not necessarily define him, but it's important. And this is less common, but it still does happen. You can actually give your appositive before the noun. A long-serving Supreme Court justice, Ruth Bader Ginsburg wrote many opinions. Notice that grammatically, because Ruth Bader Ginsburg is now the main noun, I don't put a comma after her name. So this is just has the appositive, a comma, and then that. It's less common, but it can still be effective.
So if you move the appositive after the name, then you would put a comma after the name.
Right.
The positive, then another comma.
Right. The appositive is surrounded by commas.
And
You never got that. Do not use a comma like this. But that's just a rule that you have to memorize, that you have to put the positive at the beginning and then the noun in the middle that you don't use a comma.
Well, as a writer, you get to make a choice. You could put a comma there, right? And say, a long-serving Supreme Court justice wrote many opinions. That's what it would be saying. But because really, there's a lot of long-serving Supreme Court justices. You're talking about Ruth Bader Ginsburg. So that's why you want to make it clear, I'm really focusing on her. And like I say, this is not as common to do it this way, but you will see it in some opinions and some good writing, they'll do that. But this is your main noun would not have, you almost never have just one comma between a main noun and the verb that it is, the verb that's connected to. And-
Sense without the apostrophe.
Yes. Yeah, the sentence without an appositive should always make sense. It may not be as interesting, but it should it is grammatical.
So in this case, the information that we are like adding to the sentence is not, it's not so important, so we can remove it totally from the sentence, right?
Right.
So it's like in the same way that you use parentheses.
Yeah, and parentheses, oftentimes, parentheses gives you a little more flexibility, because in parentheses, you can have a complete sentence. You could say, Ruth Bader Ginsburg, parentheses, she was one of the most distinguished justices of the 20th century. And then the parentheses. I'm not crazy about that, but you could do that. Whereas with an appositive, with the commas, you has to have it can be a noun phrase, it can also be a relative clause, but we're focusing on noun phrases here. Does that make sense for you?
Yes, I just reading my notes of oral grammar that said that the parentheses, you include information that is not really important and you can actually jump. And
Right, grammatically, it's not needed.
okay, and then pairs of comma is an interruption that provides information that contributes to the main point.
Wait, repeat that.
When we use pairs of commas,
Pairs of commas.
yes. So it's because we are including information that contributes to the main point. Like it's core information that it's kind of, I will not say crucial,
Right.
but it's important for the main point that I'm trying to express in that sentence.
Right.
And then it said that dashes is you use it when you need to put like a crucial information. Yes.
To emphasize. Yeah,
To
so
emphasize.
dashes are more emphatic. I will also say dashes are are less formal. I think dashes can be seen as informality.
I thought we're supposed to use dashes to properly write,
Maybe the emphasis.
Yeah.
to draw it.
Because they actually recommend it
Yes.
To-
Right.
in core grammar.
To use
If you
dashes.
use dashes when you want to put emphasis on a statement.
And never use parentheses
Yeah.
because when you are on legal writing, you don't supposed to put any information that it's not necessary.
Mm.
If you use parentheses, you're telling the reader that they can ignore it if they're busy, if they don't want to read it.
Yeah, and then why spending the
But the dashes you're saying are for emphasis that you
Yeah.
cannot forget.
Yes.
It's.
Oh, okay.
Essentially, said the default is using the comma.
Yeah.
If you want to emphasize it, you use the dashes. If you want to kind of downgrade it, then you use parentheses.
And parentheses kind of, they're saying, don't use it. Yeah. Well, I mean, and I also say, I feel the same way about dashes, especially if you overuse them.
Yeah.
If you overuse any of these, well, I would say the positives are actually, it's very hard to overuse those.
So that's why when you're saying that this resource, it's good to include information that it's not necessary need to be there. So do we actually need to use this resource if we are including information that is not so important for our writing?
Well, I think you have to be careful because when you say it's not important, that's not to say it's irrelevant. I would say
Okay.
it's not prioritized. It's still important because if it's not important, don't put it in there.
Okay.
Right,
Yes.
or to add, for example, well, this is just, you're reminding them, who is the appellant here, right? You could just say appellant is a citizen of the Netherlands, and that could be done, especially if you just wrote about who
Yeah.
the appellant is.
Yeah.
So you don't need to do that if it's not necessary, but if the last time you mentioned her name was 3 paragraphs ago, or you're now gonna be calling her the appellant, then you do want to include it. But you don't want to necessarily have to create a separate sentence that says the appellant is pray.
So
Cool, great.
that's actually make write less, because instead of having two short sentences, you're taking a bit of one sentence and putting it into the other sentence.
Exactly. Yeah, yeah,
So
you're combining
you-
things,
You're writing less, but you're giving as much information.
right? But you're also prioritizing, you're putting information, you're giving weight to different information. So the thing that's in the positive is, I'm not gonna say it's unimportant, but it's not the main idea. It's information here. Let me show you this one because this one might be better. So here, you've got the main noun and you're giving important information about the main noun. You don't necessarily have to create a separate sentence. And it's not that you don't, you want people to know this. And more important, you want the reader to know that you know this and that this is related to your main idea. I mean, if you're gonna say, Ambach v. Norwalk, a case that was resolved in 1972. Maybe that's not relevant, but you add that information just because you're adding words, you can get rid of it. But because this is about working in the US, and you say, I want my reader to know this is important, you add it. And then the other one, when we talk about alienage, and then you define it. And you don't have to give a whole separate sentence, even though it's still kind of long. But you're able to put all of that together and you're telling your reader, I'm in control here. I am going to take you on this journey and I'm going to show you what's right, like what's the most important thing for you to take away. Because the most important thing here is this case is a good resource about alienage. Yeah.
Will you kindly just go back to the previous one? Yeah, that one and the one before, comma after the name. Or so you didn't want to comma after
And this is the one that's less common. But I wanted to show you this because, and these are all taken from cases.
but the next one. Comma after your.
So let's look at it is like you need to identify what is the main noun for you. Like what is your writing? What you want to write? What is the main noun for you?
Yeah. And this, I mean, this could easily be written, Ruth Bader Ginsburg, comma, a long-serving Supreme Court justice, comma, wrote many opinions.
Yeah.
That can work.
Yeah.
Well, this one does sound good. And but this is, as I said, this is less common. Because what you're doing is you're giving the information about Ruth, Supreme Court Justice Bader Ginsburg. And you're putting that there. And sometimes you may want to keep the noun and the verb close together. Sometimes that's what you want to do. So this is still grammatical and it's quite elegant. It's not common. The other way is much more common.
So if I was to write a long-serving Supreme Court Justice, Ruth Bader Ginsburg, and then put in parentheses, the only female in the Supreme Court, would that also be allowed, or will I have to put a comma after Ruth Bader Ginsburg?
If you were using parentheses, I've just learned court grammar says no. But if you did, yes, you would not need another comma. There's no comma, because the parentheses are acting like commas. The same with dashes.
Yes.
They're acting like commas. So you would not use the comma there. Now, if you put a comma here,
If you put dashes there, you would take out the comma and put dashes in both sides because you want to.
you
Put
could, but
emphasis on
again, you're emphasizing the name, but again, why are you saying a long-serving Supreme Court justice wrote many opinions?
Because maybe I want to set up that she is amazing and I want to put the emphasis there
Yeah.
instead of the long-serving Supreme Court, but her name, no?
Yeah, yeah, you could. I think,
You should.
well, I mean, it's grammatical. It is grammatical, And so remember, what we want to look at is we want to look at what's grammatical. We want to look at what's efficient,
Yeah.
you know,
Yeah.
and also we want to look at what's elegant. You know, so sometimes, especially let's say you're writing things and you've been using a lot of appositives that are in this kind of the normal structure. And you want to, you know, writing is a form, you know, you are poets. Yeah, you're artists. So you may want to mix that up a little bit. And you'll see that in your reading. You'll see good legal writers, they mix it up a little bit, but they're still telling you, this is my story. This is what's important. You need to know this. Here's a little something. You need to know this. So it's this I think is very useful because look, you've got all this information and it's just one sentence. You know, and there's really the other thing that's nice about it is well, what's the subject and the verb here in this sentence? You know, I love grammar.
It's verb.
Ambach v. Norwich is the subject. And what's the verb? Is, right? And one of the things to think about, especially as you guys start to get into very complex ideas, the more you make it difficult for someone to parse your writing, the less likely they're going to like you. Because you're making them work hard. And if you're making them work hard for a good reason, that's fine. Or if you're making them work hard because it's just such a complex thing that you're talking about, that's fine. But if you're making it difficult for them to read and it could be easy, that's not fine. Because they're going to say, oh man, I know there's going to be a really great reason why I'm struggling. Like what's going on here? And then you get to the end and you say, oh man, I think that was Professor Lawler saying, wait a minute, John, come on. So here's what I'm going to ask you to do. When I say trees, because I give you nice little pieces. And you know, when you guys were mentioning what they say in core grammar, and I love core grammar, and I use the word love loosely, but you know, there are the guidelines I think are great, but they also there's things are guidelines more than just rules. Okay.
I also noticed that they say often that this is rules only the rest I learned
I like that better.
and
I like
so
that.
I talked about it with Anton, and he also said that that's the
Yeah.
So
Yeah, exactly.
I remember at my law firm that I worked for, they also have rules for people all the time.
Right. Yeah, and it can be, you know, I remember the law firm I worked with, you would write out the numbers, the first, but then if you started going further into the same paragraph, you just move to them. Okay. You know, so part of it is the audience that you're working with. I mean, because I mean, I agree with you. We want to make it so that things are
Right.
easy to understand. But if you're starting to write out 111.
Yeah. It also gets around the problem with the sometimes one of those 14 right?
Yeah.
Which is always
Yeah. Whereas with 1 through 10, it's easy.
Yeah.
I mean, and that's where I think I love core grammar, but sometimes.
Take it with a grain of salt.
Yeah, exactly. Oh, and there's our friend Clarence Thomas. So take a minute and rewrite these so that it's just one sentence. And you get to choose how you want to, what's important, what's not important, and how you make the apostles. Hello, Professor Lowe.
Hello, Dr. Bunting.
You know, I want you to write them too, Professor.
I always do, but you can't check my work now.
And once you've written them, share them with someone right next to you.
That's the longest one, yeah. We just-
One sentence. You get to choose what you want to turn into a positive.
You can add words.
You can have.
Oh, okay.
Sure. Because I'm like, give you creative.
That makes why I was like, just put it there.
Look at that suspect classification. Hideous discrimination. Foreign nationals. And if you're having any trouble, one of the things you can do is see if there's an idea or a word that's repeated in both sentences. Because that thing might be what you can use. This interesting.
No, it's wrong.
Like this. Like it. It's a little phrase that I would keep. Quotation marks, but I think the technical is supposed to be comprehensive.
Inside of our.
Yes. It's all-
And is it wrong?
I'm gonna say true. No,
Okay.
that's what you do. It's kind of like- Because one of the things is that when you write it, and then you're going through it later, because we most right, you just get the idea. But then when you write it, you say, okay, it's not in the Bible, it's here. And this is usually the way to do it. And you could even just say, when you need to come else. I mean, it's not bad, but when you're also, you're trying to be efficient, it's easy. The fewer words you use without sacrificing clarity. Okay, so this first one. Both of those are Don't be shy, share what you do. That's it. Then I'm gonna show you the perfect ones. The right answer, I'm gonna show in a minute. It's a myth, there is no right.
Yeah, I tried to.
They're longer than the original? Oh my. What about this? Yeah, all right. Isn't that beautiful? Usually short. Short is good, but also because you see this, you've got freedom of speech, you've got the subject verb again, and on a positive, you want to be able to shorten things from now. And since you've already said freedom of speech here, then you can just say, well, what is that? There it is, fundamental rights.
So how about this one?
What I would do is this whole from here. Because then, remember, the positive has to go right, usually it's right after, but sometimes it can go before. But let's just say after the noun is described. So it goes right after that noun. So you get here, suspect classification, comma, class of individuals.
Oh.
You say?
You guys have a statement.
Here's one. What you have to do.
This would be for
Yeah.
justice, comment.
Yeah, one
Because
is.
remember, it's just on here now.
Is the only one that for from the start of days in the United States. And you put like a semicolon.
No. Yeah.
The Supreme Court of Justice. Are in still comment.
And then this one is starts with this one. Individual, blah, blah. He said one of this.
You can use more than one.
In what about a semicolon after United States?
So you added to it. Then comma. What he's saying. Yeah, so he's saying. He's trying to.
You're not gonna put a comma. For justice.
Oh, okay.
There's no, you don't comment.
I mean, it's not.
Great, that's great. Yeah.
Yeah, we have by way. Yes, yeah, that's what I was saying.
Can you say? This is Georgian Supreme Court
Because it's not at
Justice.
the end.
No, he's saying, let's start from here. It's not a clarification. No, I didn't have that. Oh, I think it's I don't really understand this, however. Yeah. Yeah, you're right. I just take it. So you, I think, yeah.
By the state.
Yeah.
Oh, yeah.
And one thing you could do, although it's okay the way it is, you could actually.
Yeah, I think.
But if you want to make it clear that it's a definition, that would be.
Everything after is defined. I don't know my mind.
What did you say?
Oh, yes, so it's be, state must be several times. Use of suspect classification, comma, class of individuals that have. Yeah, yeah, so you move it.
Right, so stop. Yeah.
So here are the correct answers. Oh, it's lovely. That's a nice one. You could have something different, though. I'm just kidding when I say they're the only correct answers. This, I think, some of you got.
Yeah, that's good. It was very good.
That was good, huh? Yeah, yeah. It's okay.
Yeah, very good.
And one of the things I liked is that some of you, like, some did what I did, where you put this is the noun being modified,
yeah.
that's the appositive.
Yeah.
Some of you managed to put freedom of speech, comma, and then the definition.
Yeah.
Are enjoyed by foreign nationals.
Yeah.
Or something like that.
We had an interesting conversation about the second one. Ruth was giving the same answer you gave.
Oh, I like that.
But I was telling her that because a Supreme Court justice from Georgia is a pretty important piece of information, we can just put it between, it's not just an additional information, it's important. And they're not saying of the Supreme Court from the eastern United States.
So you're saying what the most important thing is the Georgia part, not the southeastern United States?
What we put between each commas are important. It's too crucial to just make it an additional information. But you said that, can you remind me what
That it's a description of the main noun, because the main noun is personas, and the he is the Supreme Court Justice, so you can include that information, adding information and describing the main noun. Because the sentence actually makes sense if you take out that, like.
Yeah,
Clarence Thomas, you take out the interruption and it still flows.
Yeah.
So I would think that works.
yeah,
It's got two, it's basically describing two things. So Clarence Thomas, he's a Supreme Court justice, also from Georgia, but it's all combined into.
yeah.
one.
Yeah, I mean, you can start to make a lot of different things, you know, you could put the only member of the Supreme Court from the Southeastern United States is Clarence Thomas. A Georgia Bulldog, I mean, or something. So part of it is, I mean, part of it is what it is that you want to show, what's important. And the things to remember that are important, let me see if I have it here. That you want to make sure that those things that you're, you know, that you are defining or describing, or adding information to, you know, there's something that matters and that there's something more important than what the appositive is. It's not that the appositive is unimportant information, but it's just your narrative of who's doing what. This is sort of not, it's not the main narrative that's driving what you do. I am going to, I think I'm going to break away here. Let's see. Let me hide this so I make sure. Yeah. Uh-oh, did it come back? No, it can't be good. Oh, it's on the laptop?
Yes, yeah,
My thing is?
yeah.
Yeah.
Oh, no.
It's back.
I don't know why it's here. Oh, there it is. Okay. This is, it may not be, I will post it on iCollege right after class. I actually don't think I posted it. This is another case, Ambach v. Norway. And this is a case about alienage for teachers. Near and dear to my heart. I mentioned this Sugarman dissent, and this have some similarities. So you can guess where the court's going on this. And Professor Lawler was saying we're gonna have something, a project that you're gonna have to do some serious writing about. What profession was the Henry Griffiths? What profession was involved?
Lawyer.
And what profession are we looking at here? So what do you think is gonna be the main? Oh. So we're gonna, so read this and be ready to discuss it for next week. I will give you the handouts for the final project that we're gonna be starting on. And the third vocabulary notebook is due next week. And I think that's it. Almost?
Can you unwrite the second review homework?
I put grades in your iCollege. I didn't get a paper version from you because you were out last week, I think, right? Yeah. Yeah.
I have a question. Yeah, I'll
Okay. And Professor Lawler, thank you.
Thank you. It was my pleasure. I had a great time with you.
Hey, did you do a good job with the appositives?
Yeah.
I got everyone perfectly right.
Oh, that's what I like to hear. All right, well, listen, Professor Lawler, enjoy the mountains. We'll see you next week.
Thank you. Have a good week.
It's great to see you and hear you.
Good to see
Bye,
you and
everybody.
hear you.
Have a good week. Be safe.
Said the grades are on
They should be on for which?
for the flashing line?
Not everybody.
Oh, okay.
No, not everyone.
About your comment for vocabulary, about using the overbalancing. This is something interesting. We discussed it with Anton. Okay, so I found this, like usage of these words in a number of sentences, like a number of textbooks. And I quite liked it, and I started using it. And it's not like I used it only here. I used it in the class also.
And how was that? Okay.
Like it was okay, but it was not graded.
But we discussed with them, so he looked at my thing, and at the beginning, he was also like, I am not sure whether you use this word in this context. But then we talked about it, and we looked at it, and he went to do his secret.
He did it, a
Sources.
little corpus.
Right,
Yeah,
right,
exactly.
and he said, you know what, you're right, you.
Well, I was wondering, I had a feeling that's gonna be the case. So-
But like, and I searched myself after you asked this question, and like, this is something, and I seem to like it, it's like very easy structure.
Well, it's a
And
nice,
like a nice
I
way
mean,
to
I've never heard
to
of it.
compare something like funny to arguments and about, you know.
So the overbalancing outweighs it, right?
Yeah, basically it is a synonym of output,
Okay,
yeah,
okay.
yeah. And I mean, you can, maybe this is more familiar. So
More
if you
familiar.
say it's not familiar, maybe I should stick.
Well, one of the things you can talk to him about, it. Ask him to look at it in corpus
Yeah, he did,
and
he
see
did.
where it's coming from. Maybe it's coming from legal documents.
Mm.
So maybe it's something that's used by legal folks, maybe it's something that's used by financial people. or something.
Yeah.
I mean, I've never seen it, but
Yeah.
I am.
But if you say that I would rather not use it, because like, I don't want to confuse anybody, and I don't want, because I already had this conversation with Nacho, now I'm talking to you, and I don't want to go to each person where I write it to
Well, I
explain it, right?
I think there's a balance, because I think it's good to be your own, have your own voice as a writer, and to use the vocabulary as well, and when you make it clear like that, it's not as big of a problem.
Yeah.
You know, the challenge is you don't want people to think that you've made up a word. Kind of what I thought. I was like, I've never heard that before, but I also realized I don't know all words, you know? But I mean, and if you use it enough, I'm gonna be familiar. You know, so I think it's okay. But it's good to know where other people,
Yeah.
other good writers. use it. Because if outweigh is the same as overbalance. Kind of like outweigh, but that's just me,
Okay, okay.
you know? So, but it's cool that you're experimenting and you're creating your own voice, which is good. So that's good.
Thank you.
Yeah, it's okay. I didn't get everybody's grade.
Oh,
So,
thank you. I wanna ask you some stuff, like. I'll bring it up, but the thing is, for instance, I don't agree with something, but, because.
hang on, I'm gonna
I-
hang up, on Professor Lawler. Oh, she's already left.